Hi, good afternoon, everybody. My name is Alexander Rufus Isaacs, and I'm delighted to be the host of today's episode of War Stories. War Stories is put on by the litigation section of the Beverly Hills Bar, chaired by Rudy Lara. If anybody is interested in joining the executive committee of the litigation section, where we plan events such as this, please let us know. We do have some openings at the moment. In a moment, I'm going to be introducing our speaker. If you do have any questions, please put them in the chat function, and we will probably answer them at the end, towards the end of the program. So it is my very great pleasure to welcome to War Stories today my good friend, Neville Johnson, who I confess dragged me kicking and screaming into the Beverly Hills Bar about 10 years ago. So this is kind of payback, Neville, for that. Neville is the senior partner at Johnson & Johnson in Beverly Hills. He graduated UC Berkeley. He got his law degree at Southwestern. He's tried over 28 civil jury trials and 70 civil trials and arbitrations without a jury. He's a member of ABOTA, which is the American Board of Trial Advocates, and he's on the board governors of the CALA, the Consumer Attorneys of Los Angeles, of Public Justice, and to the Beverly Hills Bar Association, where he headed up the entertainment law section for a while. He's also served as the adjunct professor of entertainment and media litigation at Southwestern. Hollywood Reporter has awarded him the ultimate accolade of legal legend. Neville has litigated and settled countless cases against a wide array of defendants concerning royalty accounting, profit participation, publicity rights, idea theft, copyright infringement, and many other entertainment law matters. However, his greatest pride has been in defending the privacy rights of citizens against misconduct by the media. His work in this field is perhaps best summarized by Professor David Elder, a leading expert on the law of privacy, who published the following special dedication of Neville in his treatise, Privacy Talks. To Neville Johnson, who has led the charge, often successfully, and always creatively and with great passion, in exposing some of the worst outrages of media news gathering. Neville ranks with Brandeis and Warren as the great defenders of privacy. All America is in his debt. That's a pretty nice accolade. Where did that come from?
I don't know, but my mother was very pleased.
Neville, we're here today to talk about the case of Sanders. Let's start off by saying, how did you get the case?
So I was helping, this is in, I guess, the early 90s. I was doing pro bono work, helping poor musicians. And I did a contract for one person who later came into my office and said, the group wants to leave the contract and I want you to go after him. I said, well, what happened? He goes, well, I was on a television show called Primetime Live, and I used the hidden camera, and I'm a tarot card reader on a 900 number, and so they fired me, and nobody will talk to me anymore, and I'm totally humiliated. And I said, well, that doesn't sound right. I don't think they can do that. Now, mind you, I had never heard of the Tort of Intrusion as of that day. I went into my law library, came out and said, there is a tort called intrusion, and I think you should go after ABC. And he said, fine by me.
And this was, I believe, Naras Kursis, his name was?
His name was Naras Kursis. His name as a producer was Paul Hyland. All he ever wanted to be was a record producer.
And there was another plaintiff, and he was one of the plaintiffs in the case. The other plaintiff was Mark Sanders. Did Kursis introduce you to Sanders?
Yes, Mark Sanders, who was a budding comic, stand-up comic.
Can you explain the basic fact pattern of what led to the lawsuit?
So the psychic marketing group, I guess it was called, was in, I think it was in Hollywood, and it was a 900 number. People would call up and pay X amount of dollars per minute to get readings on tarot cards, or in the case of Mark Sanders, he was claimed to be a clairvoyant. And and there were cubicles where everybody worked at. It was closed to the public. And this woman named Stacy Lesh, who had just graduated from college and was an intern at ABC, made a false application to be an employee and was an employee and worked there for a week or so, and wore what they called a hat cam, which was a camera that was embedded in a hat that she wore every day. And she taped all of her fellow co-workers. The thesis of the show was that you can't necessarily trust what psychics say, which is not exactly bombshell news, but that was what they were trying to show, dishonesty or fraud. There never was any dishonesty or fraud going on, and no one had ever complained about it, but it marked the end of the psychic marketing group and all those jobs, and it hurt 20 or more people who work there.
Most people are probably a little skeptical of psychic networks of this sort of nature. But how did Cursus and Sanders view the services they were providing? Did they recognize that they were basically kind of hoodwinking people, or did they really believe that they were providing a bona fide service? Absolutely not. They totally believed they had this ability and talent. And Cursus, for example, had been in a long time committed relationship with an astrologer who, when I would see them, would want to know all about my birth sign and date of birth, et cetera. And I mean, they were very, very, very serious about it. And, so many people in our country go to see psychics and talk to them. And that's just, people want to believe in them, let them believe in it. Stacy Lesh recorded Sanders and Cursus doing what exactly? What she did was she taped pretty much everybody who was working there. At one point, she got up on a chair and did a survey of the room. In the case of Sanders, they talked, but in particular, Sanders gave her a reading and talked about her inner child, for example. And as for Cursus, it was just, I think, more or less just talking to him, seeing him around. Cursus had an interest in tarot cards as well, did he not? He read tarot cards, yes. Yeah. So when the program came out, what effect did this have on Cursus and Sanders? What were they complaining to you about, apart from getting fired, Cursus getting fired from the group? Well, the loss of the right of privacy and the fact that they were humiliated as a result of this and hadn't done anything wrong. And that led me on this incredible odyssey that took, 8 or more years, all the way to the California Supreme Court with a full-on trial, and to help establish the boundaries of the right of privacy in a news-gathering context. And my first case in the history of the United States that I'm aware of where more than $1 was granted in compensatory damages, and the first case in the history of the United States where punitive damages were awarded, and ultimately it held up on appeal. So let's talk about the complaint. I believe there are 2 causes of action: common law invasion of privacy by intrusion and violation of Penal Code 632. Is that correct? Yes. Can you talk briefly about each of them and what the issues were with each claim? Well, the court bifurcated the case. I don't think I wanted that, but we heard the 632 claim first. So Penal Code 632 has a civil component, and it basically says you cannot record somebody without their permission. Now, at the time, there was a dichotomy in the law as to what Penal Code 632 meant. And one of the strands was whether or not the conversation could be overheard.
by somebody else. And if it could be overheard by somebody else, that vitiated the claim. Another theory was that, was there electronic recording? Did you have an expectation of electronic recording? And in this case, they bifurcated the case, and the jury found, yeah, other people could hear. Of course, it was other people who worked at the psychic marketing group. And by way of note, I later on brought a case also on 632 that had the issue of, and went to the Court of Appeal in Ninth Circuit as to 632 and whether it was electronic recording or could be overheard. And at that point, I lost. And from Judge Kaczynski, who has since become my friend, but it then went ultimately, the California Supreme Court took it on and said, no, the rule is, do you expect electronic recording? So if we went back to in time to Sanders in 632, I would have won clearly at that point. But in any event, we then went ahead with the common law cause of action of intrusion, which basically says, was your privacy invaded, and would it be outrageous to an ordinary citizen as to what happened? And in this case, it was taping. It was the taping itself of video inside a work environment. And that's what they fought against. And, you know, to cut to the chase, we established that you do not expect to be taped electronically by your fellow employees at a job. And so that's kind of what it came down to.
Let me talk a little bit about discovery. For example, I mean, what were the main depositions in the case?
Well, first of all, let's put in context who I was and what I was at the time. I was, it was Neville Johnson and Associates. I probably had, you know, a couple of younger lawyers working for me, but I was, you know, not well financed. And I would also say I had no idea what I was getting into. No idea whatsoever. And,
how many cases had you actually tried at this stage?
I don't know, 5, 6. But this was, so the initial firm against me was Christensen, White, Miller, and Andrew White was the partner at that firm. They were a big operation at that time. And I will say, and then he ultimately split off and it became White O'Connor, and then it merged into a New York firm as well. He has since left the practice in law, but he was really horrible to me. And one of the things I put in several declarations was, I said, why are you being so difficult in discovery? And his response was, because you're an asshole. How do you like that? So everything's delivered Friday at 5 o'clock. No, they don't want to grant extensions or common courtesies. No, they're not going to answer stuff they should be answering. I had to make motions to compel, fly back to New York a second time to get the deponents to answer the questions, etc. And put up with their putting down of me. You know, I remember going into court one time and, you know, they're saying to me, you're a joke. Okay, that's it. So it was little old me against 4 or 5 attorneys on their side, and they played dirty all the way through. I mean, when we get to the Court of Appeal, or unless you want to talk it now, I'll talk about the fundamental dishonesty.
Yeah, we can take that when we come that episode a little later. When you were taking the depositions, what were you seeking to establish?
Well, first of all, I want to say that one of the things that I did was I named everybody. I named the producer, I named the editor, I named the Stacey Lesht, and ultimately, then we got far down the line, but then the court said, you know, it's taken up so much time. I think you should get rid of the other defendants, except Lesht. And I did, but that's something I did later on in other cases as well. I said, you're all going down for this. You're all complicit in this overall. What did I want to get from them? I wanted to show the outrageousness of what they were doing. And I liken it to a fraternity prank. A bunch of guys saying, let's get together, ladies, let's get together and go to LA and live in a nice hotel, and we'll go tape every day and see what we can find. And to show this is what the ultimate ruling in the case is, that you cannot violate a law of general application to gather the news. In other words, we have a right of privacy. You don't get to invade our right of privacy, news media. You don't get to breach a contract, news media. Who made you the FBI that gets to go in and do this? And so that's what I want to know, was the genesis of the story and how the story came together to show the ultimate unfairness of the hidden camera, because the hidden camera is effectively a little morality play where the ending is preordained. Somebody is going to go down, because being on a hidden camera is per se bad. And so that's what they wanted to do, was it's titillating, it's entertaining. And they wanted to see somebody suffer at the end of the day. And so I was exposing the fundamental wrongness of the hidden camera, and ultimately that it is wrong to lie to get a story. Why should we believe what anybody in the press has to say if that person lied to get the goods, the supposed goods overall? It diminishes the credibility of that journalist.
I was going to come to that later, but since you've raised the issue, do you think there are any instances, for example, national security, consumer, product fraud or anything like that, where some sort of deception by the media is justified to get a story on the bad guys?
If I had to go black and white, I'd say no, it's not justified. But this is not the first time I've had this discussion. And if somebody was going to blow up the World Trade Center, I wouldn't take that case. And I wouldn't care if they lost, if they had brought a civil proceeding overall. We've been presented cases involving the hidden camera over the years. For example, one or two cases of the To Catch a Predator, where in one case, my potential client hadn't been there for more than, say, 10 seconds and got out of there. And he was going to, his life was a shambles as a result of that. And the classic story there was the case in Texas where a DA had interacted with the To Catch a Predator team and never did anything. And the cop showed up at his house and he blew his head off when they did. And then he brought a wrongful death action, or his family did, and they successfully settled, and the show went off the air. But there the problem was, and that's where an even more egregious situation is, where the police are working in concert with a private organization that's trying to trap people, and the news media. And my position is the news media is supposed to be watching the police, not going into business with them. But what had happened at the time I was doing Primetime Live and the hidden camera cases, Primetime Live, which has since merged into 2020, was doing more hidden camera cases than all the other networks combined. And they were doing typically one hidden camera show a week. That was the lead show. And they always did it during sweeps week because it was going to get ratings overall. And so in 1993, 1993, when this was happening, the typical show was a hidden camera show and OJ.
Were there any hidden camera shows about OJ?
I don't think so.
Yeah. Let's go back to the case a minute. So the case proceeds to trial. You said earlier that it was bifurcated and that the jury ruled for the defense on 632, but they ruled on the plaintiff's favor on the intrusion tort, did they not?
They did so, and what was interesting was that our jury, the foreperson, was the then mayor of El Monte, California. So, yeah. And then I talked to the jurors afterward, and they said, well, you know, we weren't going to give these guys millions of dollars, but it was terrible what they did. In other words, the fact that they were in fact psychics didn't help them at the end of the day in terms of getting damages. But I think we got $330,000 for Sanders and $330 for Cursus, and then for each of them another $300 in punitive damages. But then what happened is that after the jury verdict came down with compensatory damages, we had the weekend off. And over that weekend, I got a phone call from Neris Cursus saying, I really want to thank you, man. And I said, are you back on the sauce? Are you drinking again? Because he had relapsed into severe alcoholism after the show came out, and had broken up with his significant other of 10 years or whatever. And on the stand, counsel for ABC tried to make him, you know, basically say, you're a total loser, aren't you? You never made a dime in the music business, and you make your money reading tarot cards, and attempted to humiliate him. And I still regret that I didn't go grab Cursus, who was in Culver City, as I recollect. And the next thing I know is that Neris Cursus is dead, and he drank himself to death. And then the jury came in with the $330,000, and the judge says, you can tell the jury now what happened. He died, and then there was a gasp from everyone. But that shows you, for me, the cruelty of the hidden camera, of what happened. Somebody died, somebody lost a significant other, lost her lover. Parents lost their only child. He was a very nice person. And so what if he read tarot cards? So that was, and let me just say a minute about the effects of the hidden camera. This is what happens. When you have been on a hidden camera, at that time, it was like 12 to 15 million people would see you. You never know after that when somebody's not going to say, hey, didn't I see you on the television show? And, you know, what's the deal with that? And I'm sorry, but we don't have a job for you. And it affects everybody in your family, and that you have interpersonal relationships with, and it affects everybody in society, in your business, or whatever else you're trying to do. It never goes away. And in this world today with the internet, it's all the more worse. You can never get away from some alleged misdeed that happened 30 years ago.
Did the fact that Cursus died have any effect on the damages award?
Yeah, I lost the punitive damages portion, as I recollect, and there was going to be a retrial that happened, but ultimately we settled with the other side. But yeah, we were going to have to retry the case.
So you settled the Cursus side of the case, and you continued with Sanders, or at least the other side?
No. I settled Cursus after Sanders was finished.
Okay. So there was an appeal, was there not?
Boy, was there an appeal.
Tell us about the appeal.
So they appealed, I responded, and to my horror, I lost 2-1, with them saying, the court saying, well, you know, he could be overheard. So therefore, the common law intrusion piggybacked on 632 wasn't going to work. But I had a 2-1 dissent. Bano Spencer was the justice who dissented, and who was the chief justice. So I did not know at that time that counsel had cheated me, which I'll explain in a minute. But what I did then was I made a petition, which you know is discretionary, to the California Supreme Court, and they took it up. And I brought in as my co-counsel David Elder, Professor Elder, I had read every privacy case in America by this point. I was a library rat. Remember, this is before the internet made it so easy. And there was one treatise on privacy by Professor David Elder at Northern Kentucky University. And so I got a hold of him, and he became co-counsel with me. And then we went to the Supreme Court together writing the briefs. But what happened in the Supreme Court, what happened in the Court of Appeal was this. Counsel had filed, had in quotes, lodged as exhibits to the Court of Appeal videotapes that were never in the record. He had goosed these videotapes, selectively edited them to be in the favor of ABC, and never told me. And that's not how you put evidence into the Court of Appeal. You ask for the exhibits to be sent to the Court of Appeal. And so I want, you can, if anybody, I won't get into it much, but if you want to read all about it, it's attached as one of the exhibits that's given in connection with this talk here today, the brief that I did to show what I had to do. And I went over to counsel's office. I said, what did you submit? And then I looked at what they submitted and I said, that's never been an evidence. And then they said, well, come over again. There's another one. We gave you the wrong one. I looked at that. I said, that's never been an evidence. So then I flew to San Francisco to the California Supreme Court, and they put me in a room and said, here's the tapes. And I said, that ain't the tape. That ain't in evidence. And so then I made a motion to the Supreme Court, but we were going to have an oral argument like the day I submitted the motion. So they never ruled on it. And then I tried to make a motion when it went back to the Court of Appeal, and I tried to get attorney's fees, and the court didn't do anything with it. But that's what happened there. And I think that's that's a major reason why I got an adverse decision in the Court of Appeal. I was shocked.
Before you go to the California Supreme Court, Shulman comes down, right?
What's that?
The case of Shulman.
Oh, yeah. So
the news reporter. Does
yeah,
that alter the landscape for you legally?
No, but we should talk about it. What happened there was at the same time, another hidden camera case, the Supreme Court of California accepted, and that was the Shulman case. And that was where a woman was in a bad automobile accident in Lake Tahoe, and they filmed, it was an emergency medical TV reality show, and they filmed her on the side of the road saying, I want to die, and moaning. And then they filmed her in the medical helicopter ambulance. And so we wrote an amicus brief, Professor Elder and I, and the court said when she was lying on the road, that was public. Anybody could hear. But what were they doing taping her in the ambulance? That was wrong. So when that came down, then it was clear sailing for us. The court said, please write your briefs, and we did.
So the test is really becoming, is there an objectively reasonable expectation of confidentiality? And that's going to decide most of these cases, correct? Yes, right. Did you have an expectation of privacy, of privacy? And is it outrageous what they did? And the Court of Appeal essentially held that because the co-workers could overhear Sanders and Cursis when they were being interviewed by Lecht, that they therefore had no expectation of privacy, and therefore they failed in their intrusion tort. Well, that's what the Court of Appeal said. That's not what the Supreme Court said, which said that you do not expect to be taped. Who would ever expect that? And why should that be allowed overall? So in other words, the Court of Appeal did not see any gradations, for want of a better word, within the expectation of privacy. They basically say, if you can be overheard, then you cannot sue for the tort of intrusion, correct? Yeah, I mean, put this in the context of where the news media is in the legal system. Courts, the news media was just, for the most part, winning every case that involved
privacy for the most part. And one goes into a case, I think, with a prejudice against the plaintiff because a court does not want to be perceived as being anti-First Amendment overall. And because we've become inured to invasions of privacy overall. In fact, one of the things that Mr. White said in one of the, it was publicly to the National Law Journal, was that I think what we can get out of this case is the diminishment of the right of privacy. And that's what they were pushing.
So during argument in front of the California Supreme Court, did you have a feeling which way it was going to go?
Absolutely. First of all, it was interesting. The court held the argument in the assembly room or the biggest classroom of the Cal Western University School of Law in San Diego, just as the Ninth Circuit, when I argued another case involving a hidden camera, held it at Bolt Hall. But in any event, I guess they're kind of sexy cases for the courts of appeal. Yeah, the questioning made it clear that the court was going our way. You know, another interesting aspect of the case was that the news media as a whole came in with an amicus brief. And I'm talking like almost everybody, a who's who of counsel for the news media and every, you know, major news organ overall. And I commend to people, if they're interested in this, to read our brief here, which is the opposition to Amici brief of the American Society of Newspaper Editors, etc., in which Professor Elder and I take the concept of hidden cameras apart and just explain the bogus nature of the arguments that are made by the news media. And one of the things that they like to try to trot out was Nellie Bly, who in 1890 went into an insane asylum and exposed the horrors of that in New York. Well, it turns out that Nellie Bly was a joke subsequently at the time, who went out of, they called it stunt journalism, who was held in disrepute by many of her peers and her generation overall, and is no angel when it comes to investigative journalism. And I want to also make it clear, I love investigative journalism. There's nothing better than it. And I would have been an investigative journalist if I hadn't been a lawyer. I was in journalism in college and for a short time after college as well. So, you know, I read 4 or more newspapers a day and every day, and have done for years and years and years. So we're not against investigative journalism. This is, you know, another thing about investigative journalism I should mention that I think is interesting and I learned out of all of this is that newspapers and news media today, they shy away from investigative pieces, because if they do, that bank, that car dealership is going to pull their ads. So they're very expensive to do as well. But this is a very cheap and easy way to do investigative journalism when you've already figured out somebody is going down overall. So in one case, I remember I was called by a client saying, I got ABC outside my door. They're slipping their card underneath. They want to talk to me. This is on Beverly Drive in Beverly Hills. So I drove over and I talked to the journalist and the camera crew. I said, turn that camera off. I said, what are you, the Gestapo? You just come over here and knock on people's door and say, I want to talk to you. And I'll tell you what, here's the offer. We go down to the USC School of Journalism, and on the stage, I get an hour to ask you any question I want. Then you can have 1 hour with my clients. That deal? No, they didn't want to do that. So I subsequently sued them successfully for stalking my client. But you think about it, who in their right mind is going to talk to a journalist when accosted on the street and say, hey, what do you have to say about this right here as to what happened? And that's their gotcha journalism overall. It still exists, but nowhere near the aggregate that I saw in yesteryear And journalists themselves are very, very confused and conflicted. And many, many, many. Okay, the New York Times doesn't allow impersonation. The New York Times, the LA Times, the Wall Street Journal doesn't allow it. Many, if not most news organizations won't do it, but there's no code of ethics for journalists. There's no code of ethics whatsoever. And, you know, that's just the nature of it.
So the Supreme Court rules, as far as I understand it, is that there are in fact gradations of privacy, and just because Cursis and Sanders could be overheld by their co-workers in the workplace, that didn't mean that they had an expectation or agreement that they could be electronically recorded without their knowledge or consent by Stacey Lecht. Is that how it comes down?
That's correct. But, you know, another thing to bring up and consider about all of this is that it varies across the country. There's no right of privacy in Las Vegas. That's why you have taxi cab confessions, which I have a problem with. Of why are you, you know, this person is acting like an idiot or is just divulging very personal stuff, and your whole job is to catch that person doing that. Likewise in New York, there's no expectation of privacy. So, you know, depends where you're doing it. But California is, I think, one of the leaders on that. And I'm pleased to report that Article 1, Section 1 of the California Constitution says that privacy is a fundamental right in California. And I always was saying, you know, the First Amendment does not trump the right of privacy. They have to coexist. And look at what's happening today with privacy overall, which, you know, we talk about it every single day. And the, you know, the big internet providers and whatever, they know everything about us practically. But that still doesn't mean they get to film us when we don't want to be filmed. But if you go into a 7-Eleven, you're going to be filmed overall. And if you are talking to somebody at a restaurant and somebody sitting next door to you is taping, or there's a hidden camera there with a mic that can do it, you're probably going to lose. And, you know, there are other cases where going to see, let's say, somebody who's in business and you have no relationship with them up to that point. In some states, they're going to say there's no right of privacy there. So it's a case-by-case analysis that you look at.
Did you get any positive press coverage as a result of the Supreme Court decision?
Well, some, not a lot. One journalist came out and wrote a story about it, and favorable. And I remember what he said to me. He says, you know, the number one thing I learned being a journalist from my mentors was when you're doing an investigative story, make sure you put out the other side in a fair basis of what they have to say. That's what the hidden camera doesn't allow. It doesn't happen. So yeah, I got stories about it, and this case was covered as it was going along by various news media. But I remember journalists who were doing it were saying, I'm getting feedback, pushback. And the other journalists, they don't like this, talking about this overall. And then there was, I think you've attached it to this, a couple of professors, journalism, one of whom, I think they're both lawyers, did a big interview with me about Neville Johnson and the fight for the right of privacy or something like that for a law review, which I thought, that's all right. I'm happy to have them cover my career.
Yeah, no, that is in the materials that's available to everybody, along with the briefs from Sanders and some other matters that may be of interest. And I believe that we should have been sent the link by email, and also it is up on the chat box.
Let me say one other thing, and also we've added the law review article that Professor Elder and I wrote after Sanders, which was a paint by numbers law review about what is wrong with the hidden camera and ways to go after the news media for the use of hidden camera overall. And we go through basically every privacy hidden camera case in history and talk about them.
No, it's a very good law review article. Anybody who is doing a hidden camera case has to read and digest that law review article. I mean, Neville, to the extent that what we're really talking about here is setting the boundaries of news gathering, do you believe that Sanders changed those boundaries in some way? Were there any practices such as hidden camera that you think it reduced or curtailed? Is there any trends that you saw within a year or so afterwards?
No, it absolutely curtailed a lot of the abuses of the hidden camera overall. I mean, I know that from talking to other journalists and other lawyers involved in the field. It was a big dent. And I was told that what is it called? There's an organization of Media Defense Resource Center. There's 200 of the biggest law firms in the United States, has a conference every year. It's only for defense lawyers, and I'm specifically not invited. And I'm told on at least several occasions that, well, what is Johnson next? And what do we have to worry about? Because I was filing a number of cases involving the use of the hidden camera, not always successfully, but doing it. And that's another point to understand. Like I said, I had no idea what I was getting into. It basically, nearly put me into bankruptcy. And when you're fighting, and imagine a news media organization, and you're a solo practitioner, that's a David versus Goliath.
So after the Supreme Court decision, the case went back down to the trial court, did it not?
It went back to, yes, it went to the trial court, which awarded me a huge amount of attorney's fees on 1021.5. I think it's I don't know if you remember if it's civil code, or I think it's civil code for performing a public benefit because I helped establish the right of privacy. The Court of Appeal, however, denied it and said no. So they weren't going to give it to me, but that's what ultimately happened. I want to say it's fascinating. This is why I went to law school. It was to make a difference in society and to talk about fundamental rights overall. So for a guy who had never done anything in privacy to suddenly get involved in this was eye-opening and exciting to do. And as a result, it led me to many other cases and a big career in libel overall. And I've enjoyed it greatly. But I mean, they're not kidding around, the news media. Since then, we've had SLAPP. Can you imagine if I had had SLAPP at this time to contend with? It would have been, which, they could have been hit with attorney's fees. And, how was I going to do? I would have had to do discovery nonetheless to establish it all. But I had to go to New York and get, hours and hours of footage to all the raw tapes to see what happened, to see all the edits that were done in this overall. Talk to the editors depose the editors about why they did this. Depose Diane Sawyer, who was so full of it. Miss Sawyer, you're telling me you don't have a record of your notes in connection with this case? No, I wiped my hard drive. Oh, why is that? Well, to save space. Totally incredible that she would say that.
The economics of this case must have been pretty disastrous for you. You went all the way up to the Supreme Court. You came back again. You are not awarded your attorney fees. There you are, essentially a solo practitioner with a couple of associates up against the Christensen firm, backed by ABC with all its dollars. Was this a tough case financially for you?
Well, let's see. Yeah, I mean, I didn't lose money, but I didn't make much of a profit. Let's put it that way.
But at the same time, this has been an important case in helping to build your career, is it not?
Oh yeah, it was a career-making case. It put me on the map. overall. I mean, after that, the Society of Editors and Reporters, I think it was called, or their magazine said, I'm one of the most dangerous media lawyers in America, which I think that's good.
Any other aspects of the case that we haven't covered so far?
I just, what I told the jury and what I want to get across in this is that a broken heart hurts as much as a broken leg overall. And the power of the media is crushing when it is used wrongly overall. And we have to be careful about what we're doing, writing and publishing. That's basically it.
There's a tension, is there not, between the desire in some members of the media to sensationalize stories and boost ratings with what you call the general application of the law. Have you found that in-house counsel at the media companies recognize this?
I don't know if I mentioned this, but that group I told you about, yeah, I'm not allowed to go.
Then you're then allowed to go to CALA, though, are they?
I went to the ABA convention, the American Bar Association convention on communications law several years ago, and somebody comes up to me. This is, for plaintiff and defense lawyers. There's basically 98% defense lawyers. So somebody said to me, "What are you doing here?" I said, "Well, it is ABA, etc." The haughtiness of media is extraordinary overall, and they don't admit that they're wrong, and they want to push it out as long as they can, and they want to wear the other side out. And there are virtually very few plaintiff lawyers in libel and privacy willing to go against the media because of the cost, expense, difficulty overall. Very few who will work on a contingency basis, which I did in the case of Sanders. And I'm doing like a big case right now, and it's half hourly. But it's still going to cost my client a lot.
Any other hidden camera cases you've handled since then that you want to talk about?
Well, there was DeTeresa, which is the Ninth Circuit case I mentioned. That's where Anthony Radziwill, he would think would know better, who was a producer. He's son of Lee Radziwill, and went up to the door of DeTeresa. She had been the flight attendant who had served OJ on his famous trip to Chicago and secretly taped her at the door. And that's the one where I lost on an interpretation of 632. Since then, I've had others that I don't really want to talk about because I don't like talking about my losses. But the court found that there wasn't an expectation of privacy. One of them, it was in Arizona, and it was a medical laboratory, and somebody was taped inside of a medical laboratory, and they said there wasn't an expectation of privacy in that situation. And the other one was somebody who was taped at a restaurant overall. So those are ones that come to mind. Oh, and I did one in New Jersey for 3 policemen who were taped when they put a car with cameras inside it. And then they had these 3 black kids driving around all in New Jersey. And eventually my clients stopped them in the town and did a search and let them go. And they tried to say it was, what is it, Blackwell driving or something case. And we sued them for that. But what happened there was that that was right when there was a terrible scandal with the New Jersey State Police on the Turnpike, who were stopping people for racial reasons overall. So it was a very, very bad time for us to be prosecuting that case. And so the court found that the cops did not have an expectation of privacy in that circumstance, but it was totally a ridiculous, an unfair story that was done. That's these little experiments that that the media likes to put together or did like to put together. I mean, that's not the way you do journalism. I mean, there is a question, and you know, for example, testers. Can testers, if I'm not a journalist, you know, can I go out and show racial discrimination because they won't rent me a home or sell to me? Yeah, probably. I think so. Can a journalist do that? Depends on the circumstances, but maybe. And I'm not saying that they can and shouldn't. But when you are impersonating and getting a job and going inside, that was the Food Lion case happening at the same time as my case, where they did terrible damage with false employees. This is in the South, and I was in regular contact with the lawyers prosecuting that case, exchanging information because they were against ABC as well, and they were well financed. That's where I certainly draw the line: is do not put in false employees. But one of the ones they trot out is that a Wall Street Journal, I think it was a chicken factory, chicken processing. He got a job there, but when he wrote down who his last employer was, he wrote Wall Street Journal. So he didn't really improve.
Yeah, he's a cutie.
And you know,
yeah.
He didn't film in there. He wrote about what he saw. And that was another thing, is they talk about Upton Sinclair, you know, who went and wrote The Jungle. And I said, he never impersonated. He talked to the factory workers after their job every day. And ladies and gentlemen, he wrote a novel.
We have a question from Leah Kunkel. Says, Neville, can you please talk about any notable privacy concerns or issues with respect to deceased celebrities?
Oh, well, that's the tragedy. I don't know if it's tragedy. It's just a fact of life and death, is that the right of privacy dies, passes, ends with the death of anybody, whether or not they're a celebrity. One notable case was the children of Errol Flynn sued Charles Higham, who wrote a book that said their father was a Nazi sympathizer. Court said that's not going anywhere and tossed it out. The only expansion of the right of privacy in a post-mortem situation is about 3 years ago, where a young lady had taken her father's Porsche joyride and unfortunately was decapitated in Orange County. And the court there said, we are expanding the right of privacy post-death because a family has a right to grieve. And they see the cops had photographed this gruesome scene, and it went up on the internet. It's probably still after that. And the parents were terrorized in their family with mean, nasty comments about that overall. But I don't see the rights of deceased people, their families having any rights, whether it's the right of privacy or libel.
Does anybody else have any questions for Neville? Well, I'm not seeing any more. How do you analyze the Kobe case?
The which case? Kobe?
Kobe, yeah.
Oh, well, that's totally the right decision. And that's, you know, that's a follow-up of the case I just mentioned, that the family has a right to grieve. And what are they doing? You know, they shouldn't be doing that.
It's very macabre, isn't it? Okay, Neville, I think then we're going to draw this to a close. We're up on the hour. It's been entertaining. It's been very educational, and I can't thank you enough. We really appreciate hearing from you, and we look forward to doing another one of these next time you're back out down from the California Supreme Court. So thank you very much for your time, and thank you for everybody for attending this afternoon. You will be getting your MCLA certificate separately by email, and I'm seeing lots of appreciative comments coming in the chat column now. So thank you very much, everybody. We really appreciate you being part of this, and thank you again, Neville.
Thank you. It was an honor and a privilege. I really appreciate it.